No, you hold up. Don't tell me to hold up. You sit up there and tell me.
I'm not lying to you, Mr. Simpson.
Oh, we don't want to do that. We're done. We're done.
Do not smoke weed, baby.
We're done.
I'm never.
We're done.
Listen, I'm not lying to you.
You do not yell at me.
I'm not lying.
Do not yell at me ever.
Hold up.
No, you do not hold up.
The 14th District Court for County of Washington, State of Michigan is now in session. All those having business before the court are near. The Honorable Judge J. Cedric Simpson and Judge-elect Janana Kamau.
You may, yeah. And before I take the waiver and we get to the other cases, I'm just a matter of just personal indulgence. Sorry for coming out a little bit late, but it is, for me, this is a very joyous occasion having Judge Kamau with me. Many don't know, she was a student of mine, which now ages me. But also I had the pleasure of swearing her into the bar. And on both of those occasions, both as a student and in swearing her in, I knew she was somebody special and that she was going to rise to levels that one may not be able to imagine. This is a stop along the way, but this is an incredible person sitting next to me, and it's a joy having her here. So I want to say that. And she likes me, unlike the rest of you. Calls the case. People versus Kyle Rainey.
That's a lot of people.
Court show, please, Assistant Public Defender, can I ask Mr. Rainey? How are you?
Pretty good. This your case?
You said Kyle Rainey?
Yeah.
This mine then, yes.
It is?
Yeah, well,
Okay, go ahead.
today it is.
Yeah, that's fine.
Thank you. We're trying to get an offer on this file that Mr. Rainey would be happy with. Not yet been able to negotiate that with the people. I'd have to negotiations and try to get the offer that
Get that done by the second, you want the 9th.
the second should be fine, Judge.
Probable cause conference, January 2nd, 2025.
Hey, Judge, can we kind of, I want to try to come to some kind of agreement today. I've already done 6 months on this case. You know what I mean? I came from one jail, got PR'd. They came and picked me up. I did my time over there and I only got a 3-month charge over there. They said they would release me earlier to a probation center. I didn't get to do that because you guys had a hold on me. I sat in there, then they came and picked me up after I got done with my 6 months, brought me here, and I've already sat for a month and have been adjourned twice now.
Okay.
I've never been in any kind of drug charges.
Sir, hold on before you go on. I don't know anything about that. It would be a bit hard for a resolution to happen today.
I did
My understanding at the last hearing, they were attempting to try to get mitigation information over to the prosecutor. If they got that over to the prosecutor, prosecutors are going to take that into account and trying to formulate some deal.
Because technically it's my first drug charge via 7411. You know what I mean? I've never been in on any drug charges. I do have charges for like a CCW.
Sir, what do you want me to do?
I want to try to get this taken care of. I got a family at home that I'm trying to take care of. Or at least be able to get a PR so I could take care of my son myself. I've been locked up almost 7 months now. I got 3 kids at home. I got a dog that's about dying. I got a property that I take care of. I run a business. I just want to try to get some kind of leeway so I can take care of the stuff that I have to as a man. I don't have just family out there that can be just taking care of my properties, taking care of my job. I was a business owner. I went through a divorce and made some mistakes. I'm not trying to pay for it for the rest of my life. I'm going to lose everything.
Would you please take that, Judge, as a bond request on behalf of my client?
Any response from the people regarding?
Your Honor, in June of 2024, the defendant failed to appear and a bench warrant was issued. It appears that he was picked up on that in late November 20th, 2020.
So what happened with that?
Sir, I left here, got picked up from Hillsdale County. They picked me up. I've been in jail ever since and then got brought here.
Do we have a showing? You know what? Chill.
Yep.
Chill.
I understand.
Sorry, Judge. I did discuss this with my client. He did suggest that he was in Hillsdale County when that.
Here's what I'll do. Let me do this.
Yes, Judge.
Because you got to teach him how he addresses a court.
Yes,
I
first of
apologize.
all.
Now this is the moment where the judge draws a clear line. He's not just correcting behavior, he's warning the defendant. You might want to check how you're operating with me. That's courtroom language for you're heading in the wrong direction. Fast. The judge even reminds him he doesn't have to do anything today. That's power. And it flips the entire situation. The defendant came in trying to speed things up. But now he's at risk of slowing everything down. So think about this. Is the defendant fighting for his freedom the right way? Or is he making things worse for himself?
No, you're trying to force your way to do stuff. And I'm just going to tell you, you first of all were gone for a very long time from this court when I had it, and we didn't hear from you. So you might want to check how you're operating with me because I don't have to do anything on this case today.
I understand, sir.
So what I'm going to do is I'm going to pass it, take him back. Mr. Feaster, I'll give you an opportunity to talk with him, look at and see whether you can verify what information he's giving the court so the court can get his bucket.
Thank you, Judge.
Thank you. Oh, they did, okay. Court recalls the case, People versus Kyle Rainey.
Ready again, Judge. Court shall feature Assistant Public Defender appearing on behalf of Mr. Kyle Rainey. Mr. Rainey, please state your name again for the record.
Kyle Rainey. Hey, I apologize for my actions, the way I acted earlier. Just a little, frustrated.
Thank you, Judge. So if we may revisit the bond that. Mr.
Yes,
Rainey-
go ahead.
Thank you, Judge. So I did have a chance to go do some research on what Mr. Rainey was arguing. It does appear that he was granted a personal bond here back on June 6th, and he was then transferred to Hillsdale. He was in Hillsdale custody until November 20th. He entered a plea on that file in Hillsdale on September the 9th. His sentence there was 6 months, which is how we got to that November 20th date. He was then transferred back to Washington County because he had missed the court date here and received a bench warrant while he was in Hillsdale County Jail. And so now he's been here for another month, which is the total of the 7 months. But he was talking about, to confirm that I did have my office call Hillsdale County Jail, and they did verify that was the Deputy Jimenez at the county jail.
That he was there
Yes,
during the
Judge.
time that he was got it.
Yes, Judge.
Okay.
And so he's hoping the court will consider a release. He wants to resolve this matter, whether that be with a potential misdemeanor or 7411, but he's not running from this case. But at this time, Ms. Londy's still considering some options in terms of a potential plea resolution, is my understanding. And so we're not ready to resolve it quite yet. We're just hoping you might consider bond.
And that's correct, Your Honor. It's my understanding that at the time that the defendant was in Washington County Jail and then eventually went to Hillsdale, he had a hold from Hillsdale for a hearing concealed on the case.
And that's what he ultimately pled to. And that's the.
And that's what the time period was.
That's when he served the 6 months for that, and now he's on 2 years probation to Hillsdale County.
Yes. So I don't have an issue adjourning it, seeing if we can work something out. The concern of the people to resolve today is that there was that other felony that just happened and he's now been pled to. So got our eyes across our T's for how to resolve this case.
Got it. Okay, let me do this then. I'm going to adjourn this hearing out to January 9th, 2025. $25,000 personal recognizance bond, but he must be placed on a GPS location tracker prior to his release.
Thank you so much, Judge. Very much, Judge.
And see, sometimes, sir, if you just talk to your attorney and close your mouth, that was done in far less time than it took you to go on your little ramble tirade. Thank you. Have a good holiday. Court does call the case of the People versus Michael Clumpton.
Morning again, Your Honor. Michael Vincent on behalf of Michael Clopton.
Your name, sir? Michael Clumpton.
Yes, right now there's no bond for reasons I'm not quite sure on. He has a bond. He had a bond of 5,000, 10%. He was in here earlier and basically he got afraid that they were going to ask for a $250,000 bond and left. But he has since turned himself in.
Oh, yeah, I did that. Because
I'm
he
not
was-
surprised.
Yeah, you shouldn't be.
No, I'm not.
So he was here, did not appear for his proceeding and left.
Yeah, he left. Or
Yep.
Say Ypsilanti, he left home.
And I revoked his bond
Yes.
back.
And I'm asking for the
So
bond.
now we
fee.
have him here.
He's here, his employer's here, Jonathan Hunt, he works full-time for Mr. Hunt. Mr. Hunt, could you stand up so the judge can see who you are? I'm not making this up.
Hello. I believe that you're not making it up, Mr.
So, I'm asking for.
He shouldn't have left. I mean, I'll
I
let you
agree.
go on, but he shouldn't have left. I mean,
I totally.
there is nothing really that I can think of that's going to indicate that he's a flight risk more than that.
Well,
But I'll let you go. Go ahead. What?
I've been retained, he's listening to me. He can be tethered to his job, tethered to his home, and that's it.
Response from the people.
Thank you. I am stuck on I am stuck on the he turned himself in part. I don't understand that because he was arrested in Canton, Michigan.
I thought he turned.
Oh.
Fit.
So not only did he leave here, he didn't then change his mind, come back, turn himself in. He got arrested. What was he doing when he got arrested?
Now this moment adds a completely different tone, almost humor, but in the worst possible timing. Saying innocent until proven guilty might sound clever, but in this context, it actually highlights the seriousness of the situation. The prosecution is laying out a heavy criminal history, ongoing investigations, and repeated failures to comply. This isn't a light situation, and joking in moments like this can make things look even worse in front of a judge. Let me ask you, do you think humor helps in court like this, or does it completely backfire?
He's innocent until proven guilty, Your Honor.
He is.
So when we were here in May, I told the public defender that I would be requesting a $250,000 cash surety bond.
That's right.
The public defender went out to the hall to speak with Mr. Clopton to advise him of the same and essentially to prepare for their defense for that argument. Mr. Clopton ran. At the time that the case that he is in custody for with bond denied, at the time that he was arrested on that file initially back in July 2023, while he was being searched by the police and when the police found cocaine in his possession, he told the police, I have a warrant for my arrest.
That's what I meant by.
He knew that he had a warrant for his arrest and again, did nothing to resolve it. When they asked him, what do you have a warrant for? He said, just drugs. He has a criminal history that includes, sorry, I don't have it already pulled up in front of me, multiple drug charges, convictions. He also is the subject of, and I feel that I can disclose this because the search warrants have already been executed. He is the subject of an ongoing statewide trafficking investigation. I am meeting with the law enforcement agencies next week to determine where that case is going. But his criminal history in terms of drug trafficking begins in 2006, where he was convicted of delivery of manufactured controlled substance. He was sentenced to a juvenile. Again, in 2006, he was charged with delivery manufacturing. In 2007, he was convicted of home invasion in the second degree. In 2011, he was convicted of fleeing in the third degree. I could continue on, including 2020. He has convictions for firearms, including CCW, possession by a felon, RMO, and that is his most recent conviction, at least as far as I can see from his lien. And because he was out on a drug case with a bench warrant, knew of his bench warrant did not meet, and the ongoing investigation against him and his associates, I had planned to come in here and make an argument for $250,000 cash surety. Today, he should not get the benefit of that argument. His bond should remain denied. Your Honor.
Anything else, Mr. Benson?
Waiting to hear on the statewide investigation, but he's not charged with that.
Oh, I understand that, but I also understand that he was here, left, did not voluntarily come back or change his mind. We now have him. He's a suspect in other things. And he didn't turn himself in.
What?
He's a flight risk
I mean,
Clearly.
he told the cops that, look, I got a warrant.
and did nothing. Motion for bond reduction denied. Bond will continue. It's set. Thank you. Okay,
We just call with.
all right. What are we doing?
We asked the court to set this matter for exam, and I humbly request that the same day, the 7th date, if that's available. This case.
Your Honor, we've talked about this before in this case. Unfortunately, the defendant is still pending competency in a matter of 15th. He's scheduled to have a pretrial on that matter in January. But I understand as I looked at the file today, it appears that his evaluation was scheduled for October the 28th in his 15th file. He was arrested and remanded on this case on October the 24th. So he was not able to keep that appointment. And I don't see that he has had that rescheduled. So I'm not sure if he can proceed to examination while competency is an outstanding issue on a different file. Just wanted to put that before the court so everybody was aware that that's what's going on.
Based on my dealings with the forensic center, when you miss, you have to do another order for competency. I've spoken to my client. I don't represent him on that case. I don't know if another order is done. I have no issues regarding the competency of my client in this case. We've been able to talk about the nature of the proceedings and everything pertaining to that. He's charged with felonious assault based on my preliminary scoring of the guidelines. Based on all the adjournments because of this other case, we are getting to the point where he's served pre-trial the amount of jail time that I would expect if he was convicted. So if the court does think it's best to adjourn these matters, I'd ask for a release of my client on this file, yeah.
Are they expecting a report back soon on that?
Because he missed his evaluation because he was in custody, he's going to need to be re-referred in 15. He's going to have a new order and a new evaluation done. The concern of the people is if there's a question by anybody that represents the defendant about his ability to understand the nature and outcome of proceedings against him, I certainly don't want to proceed forward with a preliminary examination. I definitely don't want him to go forward with a procedure or a process that he may not fully understand. First and foremost, it's fundamentally unfair to him as a defendant, but it's also a huge issue with being able to continue with the case forward if there's a question as to competency.
Can anybody from the public defender's office help? Thank you, Mr. Feaster. Yeah, no, go ahead.
Stephanie Cannon on behalf of Caldwell as it relates to his 15th district court matters. And Your Honor, no, when I emailed the forensic center, they just said that they would reschedule time with him. At that point, they hadn't, because he had only missed it by a day. And they told us they were going to reschedule it.
And use the same order.
Yes, yes.
Okay.
However, if they need a new referral, I can go ahead and have one submitted. But at that point, they said, thank you for letting us know. We will schedule time with him.
And
But I'm hearing that they have not done so.
And they haven't done it yet.
It is my understanding based on what has been said here today that they have not done it yet. I can tell the court that at the time when the referral was done and I tried to have a conversation with him, he was not doing well. He was not medicated. Things were not well. And in speaking, he has a guardian. Last time I checked, he had a guardian. And in speaking with her, she had her concerns, which is why we did one then. But this was maybe 3-4 months ago when this happened. If he has been medicated since then and things are going better, I don't know. I haven't spoken to him since that incident. So at the time, I do believe a competency evaluation was necessary.
And Your Honor, the letter that I do see in the file for case 2335 SM for the Honorable Judge Perry says that that he missed his evaluation. There was an order dated in June 27th, 2024. He missed his appointment on October 28th, 2024. In accordance with MCL, et cetera, this is a request of attention of the defendant. If the court honors this request, please notify us and we will coordinate promptly with the sheriff for evaluation via video conferencing. Otherwise, we will take no further action. I skipped a little bit in that rest of that sentence. So I don't know if the public defender, if they were copied on this letter, I can see that it was sent to public defender's office, but we're sort of stuck until it's rescheduled.
Your Honor, we have an email from Lisa, and I'm sorry that it doesn't put her last name in, and I can't tell you. It says, "Thank you. I will coordinate his appointment with the Washtenaw County Jail for next week." We got this email on November 18th. So based on that assertion, we did not redo it. We will, but again, I haven't spoken with them since then to see if things have.
So they were gonna redo his appointment that week, but did not.
They did not, apparently.
And my letter is dated November the 13th, so that email is after the letter came. So I'm really hoping we can get this sorted.
Oh, yeah, Lisa, yes.
Listen here.
So she emailed us with some different information than what.
Oh, really?
Yeah.
So is she here? But is she in the building?
She's in the building, yeah.
Okay, so when is the next date in 15th?
January 15th.
Okay, because the problem is the PD, I was just informed, you guys withdrew on that case. So you guys are no longer on it. And then, thank you for all the information. Miss,
Oh, and it says it right there. Yes, Your Honor, that is correct. We withdrew.
Feaster gave that to you, didn't he? Feaster gave that to you. I saw it. No, Miss Cannon, I saw it. Mr. Gaddy sent you up there saying, yeah, go talk to him. And then Feaster gave you that. And they just set you up. It's okay, Miss Cannon. I don't hold it against you. I know. No, it's Gaddy's fault. And then you just jumped on the pile. Here's what I'm gonna do, and Miss Cracher was. Young man, have you talked to Miss Cracher?
I don't even know who that is.
You're better. Okay, here's what I'm gonna do.
Have you talked to your
I am on the court's own motion. I'm gonna find good cause. I'm gonna adjourn this probable cause, because I want to get to the bottom of everything with regard. On his 15th district court case, can anybody tell me what his bond might be?
He failed to appear, so he may have a warrant. I don't know.
We're left on one. We have one left.
You have one what left?
We are left on case 20-0361 SM. All the other ones we did withdraw.
That other one is over in 15?
Yes, Your Honor.
Oh, Lord have mercy. Okay.
It looks like 10,000. 10,000.
Court calls the case, People versus Lawrence Watkins.
Ask the money for the.
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Watkins, who's present. Judge, state your name, Mr.
Lawrence Watkins.
Your Honor, at this time, I believe Mr. Watkins will be waiving his preliminary examination.
Before we do that, we have a violation report. Do you see that?
Yes, Your Honor, I did see the report.
Mr. Allen. What do you want?
Your Honor, I received the report yesterday. I haven't seen any of the underlying tests. It's my understanding that there was a positive test for cocaine several weeks or in mid-November, if my recollection serves me right. He was counseled for that. He has not had any other positive tests since. There has been multiple tests. Your Honor has the report.
I do.
Your Honor, Mr. Watkins reports that he has not used cocaine. He has not used marijuana since being ordered not to, and those. That's why I was hoping to.
Hold on, before he says that, if you want me to call over and get the amount.
Well, that's what I was wondering, Judge, if the lab amounts were going, if the amounts were going down progressively with each test, that would be indicative of.
Can I speak, Simpson?
You can if you want to, but you might want to let your attorney talk to you.
No, I don't mind speaking at all. I mean, as far as the marijuana, Mr. Simpson, like I said, since the day I've been going over there, I haven't smoked weed since. And I have no reason to lie to you. Why'd I lie to you? I can just tell you the truth. I would just tell you, yes, I smoke, but I haven't smoked marijuana since. As far as the cocaine, like I told my attorney, I was going through my old clothes. Like I wouldn't lie to you. I would have no reason to lie to you at all. I'm doing great in my life. I'm doing everything I'm supposed to be doing.
I showed up to court. You have to put a warrant out for me.
Can you order the results of the marijuana? I need levels.
Yeah, please. I haven't smoked at all, period, Mr. Simpson. If I did, I would tell. I have no reason to lie to you. And I can just simply say, yeah, I smoked. I slipped up here and there, but I never have. I never smoked since the day I've been to the report, not one time. Not one time have I smoked, period. Not once.
So what's up with the cocaine?
I told you, like, I was going through my clothes. I can talk. I don't mind talking. And I found some cocaine in my pocket. The only thing I did was took it out of my pocket, Mr. Simpson. That's all I did, and took it straight to the. I could have sold it. I could have did a whole lot of stuff with it. But I told you I'm doing so good in my life right now. I took it straight to the toilet stool and flushed it. I have no reason to lie, Mr.
So
Simpson.
why is it showing up in your system?
I don't know. I just touched it, Mr. Simpson. I never used cocaine in my life, ever. Just touching it.
You know,
Mr. Simpson, I would never.
listen. I've been doing this for a minute. I can't believe you're like an amoeba. What are you absorbing it through your skin like
Yes,
that?
Mr. Simpson.
Oh, okay.
Mr. Simpson, I promise you.
Give me the levels on the cocaine too, please.
Yeah, please, Mr. Simpson, I wouldn't lie to you. I have no.
Okay.
Why would I
So
lie to you?
here's what yes.
The
Ms. Lundy.
levels for the cocaine were actually included in the original report the court has. It's pretty small print. It does say 162 nanograms per milliliter for the cocaine.
Oh, I see it. They put it in there.
And it was confirmed.
And I sent that to the. I had.
So
Go ahead, Mr. Simpson.
I don't know how you get 152 million. How do you do that?
Can I talk, Mr. Simpson?
Well, you've been talking.
Oh, listen, please, let me clear this up to you. There's no
You're not
way-
doing a very good job.
Mr. Simpson. I know you want him to talk, but let me.
This is a turning point. The judge shifts from passive listening to direct control. When he says, "You are not helping yourself," that's not advice, that's a warning. In court, how you communicate matters just as much as what you're saying. Interrupting, over-explaining, or trying to control the conversation can quickly frustrate a judge. And once that frustration builds, it becomes much harder to recover. What's interesting here is that the defendant thinks he's defending himself. But from the judge's perspective, he's digging himself deeper. So let me ask you, if you were in his position, would you keep talking to prove your point or stop and let your lawyer handle it?
Talk, please.
No, I'll let anybody talk that wants to talk to me. I'm just telling you, you are not helping yourself.
I know. I don't see how, since I would never lie to you, ever, ever. I've never used cocaine in my life. Only thing I did was touch it. Ms. Willard was right there when I showed it, and I took it straight to the. I don't know if it stayed in my system when I flushed it or whatever, but I could take a lot of tests. I've never used cocaine in my life, Mr. Simpson.
How does it stay in your system when it didn't get there?
When it didn't get there.
You took cocaine out of some old clothes.
Right.
Took it right from there to the bathroom.
I didn't say old clothes out of a jacket I had that was in storage, Mr. Simpson. I would never.
And then I know you would never lie to me.
Okay.
And so then you didn't do anything with that cocaine.
Mr. Simpson,
And then somehow or another that gets into your system at these levels.
Mr. Simpson.
Oh, you got to be kidding.
Okay,
tell you what we're going to do. I'm going to wait for the levels to come across. In the interim, Mr. Allen, take him back, put him in, and then we'll bring you back out. And then I'll do that.
Okay.
I'll let you talk.
I know. Can I just say one more thing?
Sure.
Listen, Mr. Simpson, this is what I'm trying to tell you. I call every week and go drop, right? If I'm using cocaine, there's no way in the world I would have went over there and dropped. I would have came in, I would have called over there, told him something, and missed the whole thing, Mr. Simpson. I would have missed it. I would have made an excuse. I would have went to the hospital. Or I could have said this. Oh, somebody put some cocaine in the weed, and I accidentally smoked. And it was in the weed. I could have told you all of that. But I'm telling you the honest to God truth, Mr. Simpson. The honest to God truth. I did not smoke no weed. And if I did that, I could have told you that. You're a fair guy. You've been fair with me every time I came in here. Every time I ever came and seen you, you always been fair with me. So I wouldn't stand in front of you and lie to you. And if I did use cocaine, I would ask for help. I've been doing good for 18 months, period. working every day, taking care of Miss Willard grandmother for 10 months straight. I never lied to you, Mr. Simpson. I wouldn't do that when I know I can ask you for help.
Okay, I'm gonna get levels and then deal with your case at some other point. But right now, you're gonna go with my bailiff. We'll get that information and then we'll bring you back out.
Today?
Yeah.
Okay, Mr. Simpson. Thank
Unless,
you very
unless
much.
you want me to.
No,
wait.
no, I don't.
Okay,
I really
but if you
don't.
keep talking, it's gonna be tomorrow.
All right, thank you.
Okay, stop talking. Good, there we
I
go.
wouldn't lie to you.
Okay, I know you wouldn't lie to me. I'm an amoeba, leave me alone. I'm not gonna read these files, I'm just gonna absorb them. What? Court calls the case, People versus Hannah Wellman. And he might be right.
All right. 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable case of
You may be seated. I apologize about my delay. We had to swear in a new member of the 14A family, that being our new magistrate, Odetella. So court does call the case of the people of the state of Michigan versus Lawrence Waters.
Ashley Lonnie for the people.
Mike Gaddy, Assistant Public Defender on behalf of the defendant, Your Honor, who's standing here on my right. State your name.
Lawrence Watkins.
Couple of things. First of all, we have sent to council the levels.
Yes, Your Honor, I did receive I did receive them both by email and a printout. And I have shown them to Mr. Watkins. I would they do this is for THC. I'm assuming it's for the metabolite, not active. They do show that they are progressively going down, and then they well, this document speaks for itself. Obviously, there is a slight jump from 1210 to 1217 of about
Slight?
well, I mean,
Okay.
well, when
As
we look at
compared
the
to where it was, yeah.
yeah, and I mean it's 28. I think the bar graph is probably it starts at 60. I mean, if it started at 0, 1210 and 1217, 1210 would be about 2/3 the size of 1217, not 1/10. So, but it does, I don't know if certain things, obviously our body metabolizes things at a different rate. There's a significant reduction in the late month of November. And I don't know if these metabolite levels can go up with things like hydration or just how active we've been in the way our body's metabolizing. I do know that since October 29th is even in the worst case scenario, these levels have gone down well over 100 and looks like over 130 points. I'd ask the court to, if the court's concerned about this,
He needs to just tell me,
test.
and I don't mean to interrupt you, Mr. Getty, but he needs to just tell me the truth. I mean, that, we can sit there and play this game, but the cold-hearted reality of what happened is he almost goes down to a 0 after it kind of falls off, and then all of a sudden it just shoots back up. Then he's trying to tell me that on the 19th of November, that all of a sudden this cocaine through some osmosis process, I don't know how that all of a sudden just gets into his system. So he's just got to start being honest, and don't sit up here and say, I wouldn't lie to you, Mr. Simpson, because this tells me you did.
Mr. Simpson, I would take a lie detector test for you. I would go over there.
I'm done.
Okay.
Your Honor, I'd ask the court to, it looks like he's been testing every 7 to 8 days, maybe increase it to 2 or 3 times a week to allow him to demonstrate that these levels will continue to go down.
and that there will be no further cocaine tests. Maybe bring us back in 2 weeks, revisit this issue on a adjourned PC, if the court's inclined to do that. This was going to be a waiver today, but I can understand the court's concern.
I'm gonna adjourn them out 1 week to the 26th, 2024, 9 a.m. This time based upon what the court sees, defendant's bond is revoked, he's remanded.
Your Honor, if I could say, one other thing is that he's been working steady for the last 18 months. He is a caregiver for his significant other's mother. His life is a much markedly different thing now than it was even in October. This is a.
Well, he needs to tell me the truth.
Hold up. Mr.
I mean, no, you hold up. Don't tell me to hold up. You sit up there and tell me.
This is the moment everything explodes. The defendant interrupts, raises his voice, and instantly crosses a line you never want to cross in court. Watch how fast the judge reacts. You do not yell at me, ever. That's not just anger, that's authority being enforced in real time. In a courtroom, respect isn't optional. The second it's broken, the entire tone shifts from discussion to discipline. What's powerful here is how quickly things escalate. Just seconds ago, there was still a chance to work through the situation. But one emotional outburst changes everything. And be honest, do you think his reaction was understandable frustration or a mistake that cost him everything?
I'm not lying to you, Mr.
Oh,
Simpson.
we don't want to do that. We're done. We're done.
Did I smoke weed, baby?
We're done.
I never.
We're
Mr.
done.
Simpson, I'm not lying to
You
you.
do not yell at me.
I am not
Ever.
lying.
Do
I
not
can't-
yell at me ever.
Hold up. This is the
Ever.
first time
No,
ever
you
me
do
telling-
not hold up.
I'm telling
Do
you the
not
truth,
yell.
Mr.
You do
Simpson.
not talk to me that way.
Man, I can't
You
believe
do
it.
not talk to me that
I'm
way.
not trying to
Ever.
be disrespectful.
Ever.
But I came in here when I was full of garbage. You worked with me. Now I'm telling you the truth, and you telling me I'm lying to you? I have no reason to lie to you, and I know I can tell you the truth. When I used to come in here and I have nothing to stand on, you gave me every chance in the world, Mr.
I
Simpson.
did. I did. That's why
I can't believe it.
why I expect the truth from you.
That's what
I'm
I
looking
told
at the
you.
graphs.
Even when I came in here, I was full of garbage, Mr. Simpson. You let me go. I'm telling you the truth now, and you think I'm lying to you? I'm taking care of her grandma. I've been doing this for 10 months straight. I've been working. I'm paying child support. I got my name on the lease on the house. I never came in front of you and I had these things accomplished. Now you think I would lie to you? When I know that you're a man and let me finish talking, please. I didn't mean to yell at you, Mr. Simpson. I got the utmost respect for you, and I always have. I'm sorry. But I wouldn't lie to you, Mr. Simpson. I promise you, I'm so sorry for raising my voice. But I wouldn't lie to you when I know I can tell you the truth.
Don't ever do that to me.
I'm sorry,
No,
Mr. Simpson.
Shut up right now. You don't ever do that to me.
I'm so.
No, shut up.
I can't believe you doing
And I know my mom taught me better than that, but you better shut up.
I can't believe you
Shut up and turn around. Just shut up. I sat up there and I listened to you. I did all of that. I don't believe your story about the cocaine. What I was serious, do not say another word, because if you say another word, you're gone. I'm done. I went over and I said I was hoping that the graphs would come back and they would indicate to me that you had not used THC. I was hoping there was something in your story.
Man, I ain't lie to you. Hey, babe, what's the phone number? I'm sorry, just take me to jail. Babe, what's the phone number?
Go.
What's your phone number, babe?
Just go.
Yeah, babe, I'm tired, man. I ain't lying to you. You think I'm lying to you? Just take me down, man. I ain't not lying to you, man.
Ma'am, I'll hear from you, but he's not here. I'll hear from him. What's your name?
Amanda Marie Willard. But I don't know about the cocaine issue. I wasn't around for that. We got into an argument and he left, and then he came back and said that he dropped 30 for that. The weed he has not smoked at all since I've been, since he had to start dropping.
Can I just say?
I don't understand why he came in here and was like that, But ever since we've got together, he hasn't been in the streets. He hasn't been selling drugs. He's got a job. He helps me take care of my grandma who has Alzheimer's. Like, I can't have him locked up. I don't have nobody else to help me take care of my grandma right now. Like, he's really not doing anything but working, and he stays home with my grandma when I'm at work, and that's it. He doesn't even leave the house.
Yeah. Let me just say this. I've worked with him before. And the thing is, what I saw today, I've seen before with him. But I was hoping one of two things. One, that he would just really tell me the truth. And then, if not, and if he was actually being truthful with me, particularly about the marijuana use, I don't believe about the cocaine use. And I get what you're saying. You weren't there and whatever. I get it. That what he was telling me was the truth. But then I get the levels. And I'll just describe it to you this way. He's at a certain level, he goes down, and then it levels off. Okay, then he drops to basically almost zero. And then, what was that, the 17th? I want to get the dates right for you. And then the 17th, he pops back up again.
Well, I can't explain.
And so
I just know that he lives with me and my grandma. He's not smoked though at all. Like, so I don't understand that part. I don't know. Okay, so does he have a bond? Can I pay his bond right now? I have to be to work at 5 and I have nobody
Okay.
to sit with my grandma. I don't know what to do right now. He's not a drug addict. He doesn't get high. I'm a heroin addict and I've been sober for 6 years. I wouldn't be with somebody that uses drugs right now. And I wouldn't have him taking care of my 84-year-old grandma either. I wouldn't leave her alone with him if he was selling or using drugs. I smoke marijuana, but I am not on probation or anything. I can drop clean for everything except for that. And I thought he could too, but I don't know. Can I just pay a bond or something?
Oh, dear God. Are you from Milan?
Yeah, you know who I am.
I know. Oh, man.
We just went through a whole court thing with my grandma. My mom was neglecting my grandma. She has Alzheimer's. And I went to court and won in court. We won in court to get her. And I just don't have anybody, no brothers, no sisters to help me take care of her.
Stop. Is that the grandma that was taking care?
Yeah, my grandma Susie. She told me to tell you hi. She said you have to be about her age by now.
Wow. Okay. But that's grandma that was running after all of you Willard kids.
Yeah.
Okay.
I'll be responsible for him.
Hold on. Don't do that.
I will. You
No.
can take my whole check right now.
How much can you pay him, man?
I have 200 on me right now, and then I get paid tonight. I'll have 600 in the morning. And then he gets paid tonight at midnight.
Good Lord, I don't even know why. I'm gonna set his bond at 5,000. I'll give him a 10% privilege, so you need to pay 500. But I'm gonna tell you what. You've been before me before. Probably every Willard and has been before me. You know how I am. So you better talk to him. If he comes in here again yelling at me, not listening, trying to manipulate and do whatever, I'm revoking it. I'll leave it, his bond, to next week. But I'm going to trust you on one thing, and that is that you go talk to him, that you talk to him and tell him, I'm not playing. He knows that.
Can I talk to him right now?
No. So he's gonna go down. It'd be $500. He's gotta post. Post it by that time, okay?
By what
Yes, you
time?
can post it tomorrow if you can't come up with 500 tonight, when you said you get your check and you have the 200.
Well, where can I pay it at?
You can pay it at the jail. You have to pay it at the jail. Because we have
Down
to,
there or up front
I
here?
think it's up front.
Okay.
During business hours, it's up.
Yeah, it's right during business hours it's up front. Where is it after hours? IITR down there. Okay. All right.
Okay.
I don't know why. I'm gonna trust you. All right.
Well, I mean, I feel like if I can get my life together after 20 years of street, so can he, and he's working so hard to set himself back. I don't know why he just came in here and showed out like that. I really don't.
I don't need,
I really don't know why he did that.
then you need to talk to, I'm gonna trust you to talk to him about
I
it.
swear I'm gonna do more than talk.
Because
to
you
him.
know how I am, and I'll be straight with you. I'll do what I gotta do. But you're not gonna come in here treating me like that,
No, I know.
okay?
Thank
So
you.
I'm gonna leave that part to you. I'm gonna trust that you're gonna do what you gotta do. All right?
Okay.
Tell your grandma I said hello.
Thank you.
You're welcome.
This case highlights one of the most important truths about the legal system. Honesty and composure matter just as much as the facts. The defendant tried to explain his situation, but his story didn't align with the evidence, and his emotional reaction ultimately made things worse. On the other side, the judge balanced skepticism with opportunity. Even after everything, there was still a chance given through bond, but with a clear warning attached. In the end, this wasn't just about a drug test. It was about credibility, behavior, and how quickly things can turn when emotions take over in a courtroom. If you found this case as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.